We have a warrant to search this property. Step aside.
Warrant?
They don't have to show you anything. We're executing a lawful search.
Under the Fourth Amendment, you're required to present the warrant before entry.
Lady, you're interfering with a police investigation. That's a practical.
The front door was already closing when the voice came from the walkway. It was early evening. The light had begun to soften, the kind of quiet hour when a workday ends not with applause or ceremony, but with keys set down and a breath finally released. The woman at the door had just returned home. There was nothing hurried in her movement, nothing evasive. She was inside the threshold of her own residence when the encounter began. The officer did not announce a crime. He did not reference a call for service. He asked a question instead, short, direct, and unexplained. When she turned back toward him, the camera captured the hesitation. Not fear, but confusion. This was her home. She had not left the property. She had not been stopped on a road or approached in public space. She was standing at her own door. The request came again. Identification. A pause followed. In that pause, the law already mattered. What the footage shows is not raised voices or immediate hostility. It shows proximity. A uniform position between a citizen and her front door. A body angled in a way that narrowed options without touching. The officer remained outside the threshold. The woman remained inside it. That invisible line, one step wide, would later become central to everything that followed. She complied, partially. She spoke calmly. She stated who she was. The title came out without emphasis, as if it were simply another fact, not a shield. Assistant United States Attorney. The words did not change the officer's posture. They did not end the encounter. Instead, the questions continued. At that moment, the encounter could have concluded without consequence. No detention had yet been articulated. No reasonable suspicion had been clearly stated. No exigency was visible. According to standard procedure, this was a point at which clarification alone could have resolved the situation. It did not. The officer stepped closer. The space narrowed. The door remained open, but functionally unreachable. The woman's tone remained measured. The camera did not capture anger. It captured restraint. What followed was not a single decision, but the absence of one. No choice to disengage, no acknowledgement that the setting itself imposed limits. No recognition that this was no longer a casual inquiry but a legal event unfolding in real time. From this point forward, every additional second mattered. The footage would later be examined frame by frame. Attorneys would pause it at the doorway. Investigators would replay the exact moment when the encounter crossed from optional to compulsory. Analysts would ask the same question again and again. Why did it continue? Because from here on, the situation would not resolve itself. It would escalate, not through force, but through persistence. Not through chaos, but through procedure. And once that line was crossed, there would be no simple way back. In the American legal system, titles are not ceremonial. They describe authority, jurisdiction, and responsibility. An Assistant United States Attorney is not a symbolic role. It is a position entrusted with prosecutorial discretion on behalf of the federal government, bound by ethical rules stricter than those applied to most attorneys, and defined by a daily familiarity with constitutional limits. She knew the language of lawful stops. She knew how probable cause is articulated, how reasonable suspicion must be formed before detention becomes justified. She knew the consequences of silence and the risks of saying too much. None of that required her to assert dominance. It required restraint. The footage shows that restraint clearly. She does not raise her voice. She does not invoke authority as leverage. She states her name. She states her role. She asks a single clarifying question. What is the reason for this interaction? No reason is provided. This is the first decision point. At this moment, the encounter remained consensual. The officer had not issued a command tied to enforcement. The woman had not been told she was detained. The law is unambiguous on this point. Absent reasonable suspicion of criminal activity, a person at their own residence is not obligated to submit to continued questioning. This was a moment when the encounter could have ended. It did not. The officer repeated the request for identification. He shifted his stance slightly, closing the distance. His body language changed before his words did. The camera captures the shift subtly, but unmistakably. He was no longer asking. He was positioning. This is the second decision point. The law recognizes these transitions. Courts analyze not just words, but conduct. A reasonable person standard applies. Would an ordinary person feel free to terminate the encounter? At this moment, standing at her own door, with an officer blocking the only path inside, that freedom was already narrowing. She responded with compliance again. She produced identification. She did not step outside. She did not invite entry. She maintained the boundary. The officer did not disengage. Instead, he questioned the validity of her presence. He asked why she was there. He implied uncertainty about her right to be at that address. This is where the context matters. There was no report of trespass, no call indicating a suspect had fled onto the property, no description matching her. The questions were not anchored to a specific allegation. This is the third decision point. In legal review, these moments matter more than dramatic gestures. Each question that lacks a lawful basis compounds risk. Each step closer without justification increases exposure, and each refusal to disengage narrows the officer's options later. The woman remained composed. She explained, again, that this was her residence. She pointed to the door. She referenced no threat. She requested no supervisor. She simply stated facts. From the outside, it looked calm. Inside the law, it was already unstable. Because at this stage, the officer had accumulated nothing that justified escalation. He had no articulable suspicion. He had not observed a crime. He had not identified exigent circumstances. What he did have was time, and time, without lawful grounding, is dangerous in an encounter like this. This was another moment when the interaction could have ended. It did not. The officer informed her that she was being detained. That sentence changed everything. Detention transforms a voluntary encounter into a seizure under the Fourth Amendment. It requires justification, not intuition, not discomfort, not a hunch, justification. The record would later reflect that none was stated at the time. The woman did not resist. She did not argue. She acknowledged the statement. The camera captures a brief stillness after the word detained is spoken. That stillness would later be replayed in hearings and reviews. It marked the precise second when the encounter became a legal liability. This is the fourth decision point. Once detention is declared, officers are trained to reassess, to confirm the basis, to verify whether the standard is actually met. This is where many encounters de-escalate. The officer did not reassess. Instead, he continued. He asked additional questions unrelated to any stated offense. He delayed release. He maintained position at the threshold. Each second extended the seizure. Each second compounded exposure. From this point on, the encounter was no longer about suspicion. It was about persistence. The woman's professional background was not used as a threat. It was used as context. She explained that she understood the process. She explained that she was willing to cooperate within the law. She did not demand preferential treatment. She demanded clarity. Clarity did not come. What the footage reveals is not a confrontation between authority figures. It is a failure to recognize limits. The officer's authority was real. So were its boundaries. This is where the reversal begins, not through force, but through overreach. Because the moment detention was declared without lawful basis, the power dynamic inverted quietly. The officer still controlled the space, but the record had already begun to control him. This was yet another moment when the situation could have been corrected. It was not. From here forward, the system itself would take notice. When courts later examine encounters like this one, they do not ask whether the officer felt uneasy, cautious, or uncertain. They ask whether the law allowed what happened next. Emotion does not supply legal authority. Structure does. The Fourth Amendment governs this moment precisely. A person may be approached by law enforcement and ask questions without triggering constitutional scrutiny so long as the interaction remains voluntary. The legal threshold is crossed only when a reasonable person would no longer feel free to leave or disengage. At that point, the encounter becomes a seizure. By the time the officer announced detention at the doorway, that threshold had already been crossed. This distinction matters because detention is not a flexible concept. It requires a clearly articulable basis. Specific, objective facts indicating that criminal activity may be afoot. Courts do not accept generalized suspicion. They do not accept uncertainty. They require articulation. In this encounter, The record shows none was provided at the time. Standing at one's own residence is not inherently suspicious. Returning home is not a criminal act. Being present at a doorway does not create exigency. Absent a report tying the individual to a specific offense, the officer's authority to detain narrows sharply. This is where setting becomes legally decisive. Encounters at a private residence are treated differently than those in public space. The law recognizes heightened privacy interests at the threshold of the home. Officers may knock, they may speak, but without consent, a warrant, or exigent circumstances, their authority to restrict movement at that boundary is limited. The footage shows the officer remaining outside the threshold while functionally controlling access to it. Courts look closely at this configuration. Blocking a doorway, even without physical contact, can constitute a seizure. Positioning, tone, repetition of commands, these factors are weighed together. The question is not whether the officer intended to detain, but whether a reasonable person would have believed they were free to end the interaction. At this stage, that answer becomes increasingly difficult to defend. Once detention is declared, the officer's obligations increase. The scope of the detention must be tied to its justification. Questions must relate to the suspected offense, duration must be limited. The intrusion must be proportionate. Here, none of those limiting principles appear to have constrained the interaction. The officer continued questioning without clarifying the suspected offense. He did not narrow the scope. He did not verify information and disengage. Instead, the detention persisted in search of justification rather than based upon it. This is not how lawful detention operates. The courts have addressed this pattern repeatedly. Detention cannot be justified retroactively by what it uncovers. Reasonable suspicion must exist before the seizure, not be constructed during it. Prolonging an encounter to see what turns up is precisely what the Fourth Amendment forbids. At this point in the timeline, the legal exposure was no longer hypothetical. It was structural. Each additional minute of detention without justification increased potential liability. Each question unrelated to a stated offense expanded the scope beyond permissible bounds. Each refusal to disengage removed another layer of legal insulation. From the outside, the scene remained calm. There was no shouting, no physical struggle, no visible aggression. But constitutional violations do not require spectacle. They require only overreach. This is why these cases are often misunderstood. The absence of chaos does not equal the presence of legality. In fact, it is often the quiet persistence, the steady refusal to stop, that proves most damaging under review. By now, the encounter had accumulated a record, not just on camera, but in law, a sequence of decisions, a trail of moments where disengagement was possible and declined. The officers still held immediate authority at the scene, but legally, the balance had already begun to shift. Because once an encounter enters this territory, it no longer belongs solely to the officer involved. It becomes subject to supervisors, internal review, prosecutors, and courts. The system starts asking its own questions. And the most important one is simple. Why did it continue? That question would not remain theoretical for long. The moment did not arrive with raised voices or sudden movement. It arrived with stillness. The officer stood where he had been standing for several minutes, close enough to command the space without crossing the threshold. The woman remained just inside her doorway. Neither moved. The camera continued to record, unblinking, indifferent to intention. For several seconds, no one spoke. The only motion visible was subtle, a shift of weight, a hand adjusting on a belt, the door remaining open but unused. Time slowed in a way that footage often captures, but people rarely notice in real life. The kind of pause that does not feel dramatic until it is replayed later, again and again, by people trained to see what matters. This was the silence. No new questions were asked, no explanation was offered, no justification was stated. The detention remained in place, unsupported but active. The law did not change during those seconds. The facts did not change. Only the record did. When speech resumed, it did not resolve the uncertainty. The officer continued to hold position. The woman continued to cooperate within limits. The encounter moved forward without a clear purpose, sustained by momentum rather than reason. From this point on, every second belonged less to the scene and more to its aftermath. Supervisors would later pause the footage here. Investigators would freeze the frame. Attorneys would mark the timestamp. They would identify this pause as the point where discretion could have been exercised without consequence. Instead, it passed. The detention continued. Questions followed. Clarifications were delayed. The officer did not disengage. He did not narrow the scope. He did not step back to reset the encounter. What he did was remain. Eventually, the interaction concluded without arrest at the scene. There was no citation issue that resolved the justification problem. No discovery of criminal activity that retroactively validated the detention. The woman was allowed to remain at her home. On the surface, it appeared uneventful. No handcuffs, no use of force, no charges that night. But the camera had captured enough, because by the time the officer left the property, the encounter had already separated into two timelines. One ended at the doorway, the other was just beginning. The footage would not stay local. It would be reviewed internally, then externally, then formally. Each review would focus less on what the officer believed and more on what he did and what he failed to articulate when it mattered. The silence in the middle of the encounter would become louder with each viewing, not because it was dramatic, but because it was empty. Empty of justification, empty of explanation, empty of any lawful reason for the detention to continue. From here, the case would move out of the officer's hands entirely. And once that happens, authority no longer rests with the person who stood at the door. It transfers to the system designed to judge him. The first review did not happen in a courtroom. It happened in a room with no windows where the footage was played without sound. This is standard procedure. Supervisors are trained to watch body camera video twice, once as it happened and once stripped of context. The second viewing removes tone, removes explanation, removes intention. What remains is conduct. The questions begin there. Why was the encounter initiated? What articulable facts justified continued questioning? At what point was detention declared, and on what basis? These are not rhetorical questions. They are written into policy, and each requires an answer that can be traced to the record. In this case, the record was thin. Internal review does not look for malice. It looks for deviation. And deviation accumulates quickly when the justification for an action is not stated contemporaneously. Supervisors noted the setting first, a private residence, then the posture, blocking access to the doorway, then the timeline, prolonged interaction without a stated offense. Each element alone might have been defensible. Together, they were not. The footage was escalated. Once that happens, the process becomes procedural. The officer is no longer responding to a citizen. He is responding to questions from within the system that trained him. Statements are requested. Reports are compared to video. Language is scrutinized for consistency. This is where many cases narrow. Some end quietly. This one did not. Because the woman involved was not only a private citizen, she was a federal prosecutor. That fact did not elevate her rights. It elevated the visibility of the review. The standards applied were the same. The scrutiny was not. The matter moved beyond internal affairs. According to later filings, federal authorities requested the footage as part of a broader review. At that stage, the encounter was no longer being evaluated solely under departmental policy. It was being assessed under federal law. This transition is critical. Administrative violations can result in discipline. Federal violations carry exposure. The distinction depends on whether conduct is merely improper or unlawful. Investigators began examining whether the detention constituted a deprivation of rights under color of law. From that moment forward, the timeline extended. Interviews were conducted, policies were cited, training records were reviewed. The officer's past encounters were examined for pattern, though the specifics of that review were not publicly disclosed in official records. What was disclosed was the shift in posture. The officer was placed on administrative status pending outcome. His authority to act in the field was restricted. The badge remained issued, but functionally inactive. This is often the point where officers realize the matter has moved beyond correction. It had become evaluation. Months passed. The case did not fade. It matured. Legal theories were tested internally before being tested publicly. Prosecutors examined whether the elements of a federal civil rights offense could be met, not in theory, but on this record. By the time the next stage arrived, the encounter at the door had already been reframed. It was no longer viewed as a misunderstanding. It was being analyzed as a decision sequence with consequences. And the system, once engaged, does not ask how an encounter felt. It asks what it violated. Federal criminal exposure does not emerge from discomfort or embarrassment. It emerges from statutes. By the time prosecutors evaluated this encounter, the focus was no longer on whether the officer had made a poor judgment call. The question was whether his actions, viewed objectively, met the elements of a federal offense. Specifically, whether a person acting under color of law had willfully deprived another person of rights protected by the Constitution. That is a narrow path, but it exists for a reason. Under federal law, a civil rights violation becomes criminal when certain thresholds are met. The government must show that the officer was acting in an official capacity, that a constitutional right was implicated, and that the deprivation was willful, meaning the act was done intentionally, not accidentally or negligently. The Fourth Amendment right at issue here was not abstract. It was concrete. The right to be free from unreasonable seizure, particularly at one's own residence. The footage provided a clear timeline. Detention was declared, justification was not. Prosecutors do not need chaos to build a case. They need sequence. The sequence mattered. The declaration of detention without articulated suspicion. The continuation of questioning without narrowing scope. The physical positioning that restricted access to the home. Each element contributed to a theory of unlawful seizure. What elevated the exposure was not duration alone, but persistence after warning signs appeared. The woman identified herself. She stated facts that could have resolved the encounter. She remained compliant. These moments, captured on video, undermined any claim of confusion or mistake. This is where sentencing exposure enters the discussion. Federal civil rights statutes provide enhanced penalties when certain aggravating factors are present. The maximum exposure, often cited as up to 10 years, does not mean a sentence will be imposed at that level. It defines the ceiling. It signals the seriousness with which Congress treats willful constitutional violations by officials entrusted with authority. The phrase "faces up to" is precise. It reflects potential, not outcome. Charging decisions consider many factors: intent, training, precedent, and the strength of the record. In this case, the record was unusually clear. There was video, there was audio, there was a clean setting with no intervening threat. There was a detention unsupported by contemporaneous justification. That combination is rare. It is also why the case moved forward rather than resolving quietly. Prosecutors could explain it without interpretation. The footage spoke. The law applied. The elements aligned. By the time exposure was publicly acknowledged, the framing had shifted again. This was no longer an internal matter. It was no longer about policy compliance. It was about whether the conduct crossed the line Congress had drawn decades earlier. The officer was no longer viewed as a decision maker at a scene. He was a defendant in a legal structure that measures actions in elements, not explanations. 10 years was not a prediction. It was a boundary. And boundaries are what this case had always been about. Cases like this do not end when the camera stops recording. They end when the record settles. Long after the encounter at the doorway faded from memory, its outline remained fixed in official filings, training reviews, and legal analysis. The woman returned to her work. Her authority did not need to be reasserted. It had never been lost. The system recognized it without ceremony. For the officer, the consequences unfolded more slowly and more publicly. Regardless of final disposition, the process itself became permanent. Investigations leave trails. Administrative actions, federal reviews, and charging decisions do not disappear. They attach to a career, shaping how future conduct is assessed and how past actions are interpreted. In law enforcement, records matter. They determine assignment, eligibility, testimony credibility, and professional viability. An officer involved in a federal civil rights case is evaluated not only on outcome, but on exposure. The mere presence of a sustained investigation alters trajectory. This is not punishment. It is documentation. The encounter at the door did not produce a dramatic arrest or a chaotic scene. It produced something more durable, a sequence of decisions preserved in time. That sequence became teachable material. It would be referenced in training rooms, not by name, but by principle. What happens when an encounter continues without justification? What happens when a detention is declared without articulation? What happens when authority is exercised past its lawful boundary? These lessons do not require outrage. They require clarity. The legal system does not ask officers to predict outcomes. It asks them to respect limits. When those limits are crossed, the response is not immediate or emotional. It is methodical. The doorway in this case became a line drawn in review memos and legal briefs, not because it was symbolic, but because it was exact. One step wide, clearly visible, legally decisive. Years from now, the footage may still circulate, not as a viral clip, but as a reference point, a reminder that constitutional violations do not need force to be real. They need only persistence without basis. The system does not remember how loud a moment was. It remembers whether it was lawful. And once the record is made, it does not forget.